welcome back. Interested in learning more about IP with Mona and Alex? Excellent. Let's dive right into this topic together. Intellectual property, IP, is a category of property referring to intangible creations of the human mind, such as inventions or ideas. There are two types of IP rights, technical and non-technical ones. Within these two groups, patents as well as copyright and trademarks are the most important ones for life scientists. A trademark is a symbol used by a company to distinguish its own products or services from those of others. Such signs can, for example, be figurative marks like logos or word marks, like slogans. Copyright protects creative works such as music, movies, photos, artistic and literary works, or software. Since patents are the most valuable tool to protect an invention in the life science field, let's have a closer look at this topic. A patent confers the exclusive right to the owner to prevent or stop others from commercially exploiting the patented invention. There are three main requirements that your invention needs to fulfill in order to be patentable. It must be novel, inventive, and commercially applicable. Do you wonder what exactly is meant by these terms? Let me explain to you. A technology is novel if it is not already state-of-the-art. This means it must not have been disclosed to the public yet, neither by written or oral communication, nor by public use of the invention, even by yourself. So keep in mind that publishing of papers, abstracts, posters, bachelor, master's, PhD theses, research proposals on websites, news of research results in social media, or giving public presentations about your technology should be done after considering to file a patent application. Otherwise, any of these disclosures will destroy novelty and patentability of your invention. For being inventive, your idea should not be obvious for a person skilled in the art. The solution could not be expected as part of standard further development or by combination of pieces of public information. Commercial applicability is given when it is possible to produce, use, apply, or market your technology. Now the question is, what can be patented? In principle, patentable inventions include compounds like chemical substances, proteins or drugs, production processes, methods and procedures, genetically engineered products, or modified organisms like bacteria, animals, and plants. By contrast, discoveries, scientific theories, mathematical models, and any surgical, therapeutic, or diagnostic procedures that disturbs the integrity of the human body are excluded from patentability. However, this exclusion does not apply to products, specifically substances or compositions intended for use in any of these procedures. If you consider patent protection for your invention, weighing the cost-benefit analysis of obtaining a patent is another important issue to think about beyond patentability. Since filing and prosecuting a patent application is usually quite costly and time-consuming, it is very useful to evaluate the market potential of the invention early on to estimate if future expected revenues could compensate for such expenses. I will explain to you at a later time point how such evaluation is done. Now that we have been talking about IP rights and requirements for patent applications, do you know who owns an invention? No? All right. In general, an inventor owns this invention. However, things get more complex if the invention is made under an employment contract. For scientists working at a scientific institute or university, the institution usually has the right to claim any inventions made by its employees if the researchers decide to make their results public. Therefore, it's your duty to inform your employer before you publish your invention, as this gives them the opportunity to protect the intellectual property before public disclosure. Usually, universities and research organizations have a questionnaire called Invention Disclosure Form that you simply need to fill out and hand in. Based on this, they will decide if they want to claim your invention or to release the rights to you. You see, it's not that complicated. If you want to learn more about filing a patent, including the requirements and timeline, you can join Mona and Alex at their appointment with one of our patent attorneys in the next video. See you there.